Hi, this is Attorney Mike Gravel coming to you from Chicago as usual, and I've got yet another Kim Blandino video. We're going to call this one a pro se fail again. I have gone completely down the rabbit hole. In fact, I have started a Kim Blandino playlist. I'll put a link to that in the description below. I've done a couple videos. I promise I'll get back. Judge Middleton's probably happy I'm leaving him alone for a few days. I got sent a video that was too good, and then I had to go searching for another clip, and I found it. I found what I wanted so that it sort of bridges this back to my prior video where the judge was warning him about getting an evaluation or ending up in jail. Let's do it.
All right. So, Mr. Blandino, I'm going to put some things on the record. You're referring to December 30th order. I don't know what order you're referring to.
No, December 20 order. This is the Linda Marquis order.
Well, the order...
Oh, I'm sorry. You're right. It says for a status check on December 20.
That's right.
But it said December 6th.
So it's actually a December 6th order.
Yeah. Oh, you're right. I been goofed up. I apologize.
No, that's okay. It happens. But
I did set those appointments in this email.
Okay, Mr. Blandino, let me finish things on the record, okay?
Yeah.
So this is a December 6th email where Judge Marquis put a number of things on the record and made a number of findings. Of importance to what we're here for today.
I'm actually impressed that he apologized. I didn't think he had that in him.
It specifically says on page 2 of that order, paragraph number 1, that within 7 days of this written order, Mr. Blandino shall make evaluation appointments with Dr. Capel,
which is undisputed, I did.
Or Dr. Slagle, and he can contact them and they provided the contact information.
Which I did.
Pointing at anyone's a bad idea. Pointing at a judge is a horrible idea.
I also find that that office attempted to schedule appointments for you for both December 11th and December 16th. But you advised as you said here in open court, you were, quote, not available for the December 11th date, and you provided no reason why you couldn't be seen on the 16th. Instead, you decided...
No, I was never told about the 16th, Judge. All I was told is that I had an appointment. My recollection now is that I had an appointment for the 26th, and they told me over the phone. I wish I'd have recorded that darn thing. But I didn't.
Well, that would be another crime, so don't do that.
Yeah, but if I would have law enforcement there, because there's a potential crime in progress, especially if you put me in jail, that'll be a compounded crime. Yeah, they said the 26th, they said, we'll call you later to schedule the one for Dr. Slagle. So at that point, when I hung up the phone, I thought everything was fine and dandy. The email that I showed you shows you that says, and it's not a cut and paste, it's just what's called a continuation, where you got REs back and forth. And it says...
He keeps using the phrase fine and dandy, which is perfect and right in line with his Mr. Whipple persona.
It says that we can't do anything for you by the 20th date. You're going to have to work this out with the courts. Do you see that? Now, I was denied to present this information to Judge Bell last time, just to make a record, even though she had no business being in on the case. But because I'm being denied these rights, especially to make a record, it's very, very tough to do this.
Well, I do find that there was an attempt to have you go in on December 11th, and I still have no reason as to why, other than your representation that you weren't unavailable, but you don't have a reason.
No. See, this is not a static conversation where it's text back and forth. I said, is the 26th good? And they said yes.
That was good because they had an availability, but to comply with Judge Marquis' order, it had to be before the 20th.
No, that's not true. Read the order. This matter is on for a calendar for a status check on December 20th.
You're right.
So if I would have come in here...
Actually, it would have been before December 13th.
It doesn't say the evaluation had to be done by that date, Judge, and you have to know that it could very well, I could have said, hey, look, I got an appointment with Judge Capel for the 26th, and then a Judge Slagle on so on and so forth, and whoever was sitting on the bench could have said, okay, yeah, that's fine.
Let me ask Mr. Dickerson a question about that, because the order actually does say, Mr. Dickerson, that he has to make evaluation appointments but within 7 days of the order.
Exactly.
This whole time he's in contempt, of course, but I see why the judge isn't doing anything about it because he's headed for a remand any way you slice it.
Total compliance with that.
Mr. Blandino.
Yes.
So the ruling from the bench was that he had to get the evaluation done within 7 days. And
No, that's not true. It doesn't say that.
those are the notes that I have, and that's what I'm showing.
Yeah, don't go by the judge's signature on a signed and filed order, go by his note. Yeah,
So-
this is America.
Ultimately, it's quite clear exactly what.
Okay, Annie is asking very nicely for you to like, subscribe, and hit the bell notification. And if you ignore Annie, you do realize that that is considered capital felony treason.
Mr. Blandino was doing in trying to push this out past the status check. He has no good reason that he proffered to this court as to why he couldn't attend any of the dates that were offered by the psychiatrist, especially considering that those were dates that were offered for both of the psychiatrists to be present during the evaluation.
No, they offered the 26th date, Judge. I took that 26th date and they said.
I see that.
And the 26th date was only for Dr. Slagle, never confirmed for a 26th date. So the defendant never actually scheduled his site yet.
I tried to.
Since he's required by statute to have two. So he didn't schedule those within the time required by this order or by the ruling from the bench. Either one, the defendants failed and violated this order.
No, that's not true. You're gonna take a rule, this is absolutely wrong. I did that quicker than the 7 days. I called up that very day, went down to their office that very day. She said she couldn't do anything until she heard from her doctors. When I called and made that appointment, as far as I knew, the 26th date was fine and dandy, everything was good. Got off the phone, and they said, before I got off the phone, they said, we'll have Dr. Slagle make his appointment with you. And so, it could have been before or after. If this order would have said, Judge, if this order would have said, you, Mr. Blandino, shall have those appointments set before December 20, absolutely, my client, me, would have done so. It says for a status check. I've seen over and over again where they do status checks, and you go and you remand me like this.
I really like my client, me.
The attorney wants. You watch how I'm slow played through the system. Maybe a month and a half in custody before somebody comes to evaluate me. And will he be complaining about abusing the process? Absolutely not. This mental health system spends less than any place in the country. It's under a federal consent decree because of the numerous violations that they've done. And I'll tell you what, I was going to do an emergency motion to the Nevada Supreme Court prior to this hearing, anticipating that there might be some more lies here, and I said, no, we'll see what happens on this because I still got the motion to disqualify. You know, you can't sit on the bench, Judge. There's still an outstanding motion to disqualify. You have to know that. 1.230 and 1.235 is very specific. Until there's been a determination on the motion to disqualify, the court can proceed no further, and that includes you.
Okay, Mr. Blandino, so I'm reviewing the transcript from the proceeding with Judge Markey.
The transcript that I was paid for, I paid for.
The transcript says specifically, make an appointment, you'll get it in my written order, that will be issued by 5 p.m. today. That will be filed into the case and you will have access to it. I'm not going to grant a motion to remand, however, I'm going to see you back, not next Friday, but the Friday after. And we better have these appointments made, and I want verification from the doctors that they were done. In addition to the requirement of your release, you are the following. You are not to have any contact with Talia Williams privately or in a professional contact. Your question will be part of the written order. Yes, thank you very much, I appreciate that. And then you were also ordered not to have any contact with Judge Levitt or Judge Delaney.
That's interesting. He's ordered. This is from the prior hearing. The judge is just going through it, but he's ordered to not have contact with other judges. That is not a good sign.
And then there was some back and forth because you continued to interrupt the judge. Okay, so specifically, again, the judge said, we better have those appointments made, and I want verification from the doctors that they were done. So we're sitting here now on January.
Now, appointments
23rd.
made, that's key, Judge, if you appoint to
I
that, the
agree.
appointments were made. I made an appointment that they said was good to the 26th, and I was supposed to get a call
Except
back.
they were supposed to be done by December 20th.
There's nothing on that order. I was required to do within
Within
7 days,
7
which I
days.
did.
And there were supposed to be appointments with 2 doctors.
Correct.
And he knew the whole time that he only had 1 appointment.
Correct. So you can't do 50% of the work, Mr. Blandino, and then be surprised that the court is going to have issue with the fact that not only did you not follow what Judge Markey said and get those 2 appointments done, not just 1.
They refused to do them. They said it was beyond the 20th date, and I had no idea
Mr.
that there
Blandino,
was.
stop interrupting me. Based on the information before me, it appears that they attempted to work with you not just on 1 occasion, but 2 occasions, that being December 11th and December 16th, both of which would have been
I thought this was the
before
16th.
December 11th and December 16th,
16.
which is what, which would have been before.
I never got a
December-
16th date.
Ms. Blandino, let me finish talking.
Yeah.
Which would have been within the, not only the 7-day range that was discussed before Judge Markey, but well before the 20th day that was initially set for a status hearing, where you would have followed the order, we better have those appointments made, and I want verification from the doctors that they're done, the appointments are done. So, what you did do is you did 50% of the way, and I do give you credit for that. You did attempt to make an appointment, and you got an appointment, of course, all that on your schedule. I still have no explanation or excuse as to why you did not go on December 11th of 2019, which would have been within the course.
Because they gave me an appointment for the 26th. This was a banter back and forth where you're trying to reconcile schedules. The court does this with the attorneys all the time. We're setting a date. Oh, can we make it this? No, I got this, I got that. And they said the 26th. Why? You can't sit there and say that I did half the work. I did the entire amount of work. I set the appointment the 26th. I thought everything's fine. It doesn't say in this order that the appointment has to be before the 20th. And so they said they were going to call me back, or Schlegel was going to set up an appointment. Now, it may have been before the 26th or after the 26th. It's up to his schedule. But you're making it sound like I just purposely did 50% of the work and I complied specifically with this order as written. Now, if Judge Markey, wanted to do this and say, your appointments have to be set for December 20th, I would have done that. And I would have gone to the commission, or the Nevada Supreme
Mr. Blandino,
Court.
you were here in open court when Judge Markey told you that appointments had to be made and verification had to be done. You received that order that said within 7 days of that appointment, you had to have those appointments made. You didn't do that. You
Yes, I
were
did.
fine on the December 26th date, but it was made, that's well after the 7 days.
You are twisting the facts here, Judge. You are clearly biased in favor of the district attorney here. I said bias. I'm going to have to file another motion to disqualify you.
Well, you're going to need to follow the court procedure for
But
doing that.
why do you want to only do half the work? There's a motion to disqualify.
Please
You
lower your
can't do
voice,
anything in this
Mr.
case.
Blandino, lower your voice.
He's already got a motion to disqualify on file. A second one doesn't help matters at all.
You can't do anything in this case with an
I
outstanding
am
motion to
going to grant the
disqualify.
state's request to remand Mr. Blandino to custody.
Yeah.
Be taken into custody at this time.
All right, no.
I am going to order that Mr. Blandino also be evaluated while he's in custody pursuant to the pending.
Are you going to give a timeline for that, Judge?
It'll be with the, in the normal course of the.
Oh, the normal course, which could be 3 months from now until I get evaluated. This is outrageous, Judge. I object to what you're doing. You're taking an evidentiary hearing based on hearsay.
I'm advised by
and this is
the court
outrageous.
staff that it'd be 3 weeks, within 3 weeks, I would be evaluated.
I love how he's still going as they fit the bracelets on him and perp walk him out of the courtroom.
All right, is there anything further the state needs to put on the record?
Well, there you have it. That's kind of fun. What happened here is I got sent a great clip, but it was from jail, and I thought I need to find an interim date. I'm still not sure to this moment, but I'm piecing this up. This is early January. The next clip is in April of that same year. So I think that this is when he gets remanded, and the next little clip we're going to do here is him from jail.
All right, so Mr. Blandino, I normally wouldn't hear your case, but I want to make sure that you get out of custody today. So,
I'm sorry, you want to make sure what?
that you are released from custody today because you were only remanded for the purpose of going to Lake.
That's true.
So,
But I have not been able to confer with my standby counsel. How am I going to do that before this hearing?
This is good on so many levels. I haven't been able to confer with my standby counsel. Well, if you just let your counsel represent you, you probably wouldn't be in this situation at all. The fact that he refuses his representation, but requires the ability to confer with him is hilarious.
well,
And Judge,
I'm sorry. So
Ben Bateman here, Your Honor. I am here as standby counsel. I am
Sir, they found you competent, so my plan was to have you released today and give you a date in Department 12.
Am I going to be able to make a record, though? I wasn't able to make a record last time with Judge Hardy, and I need to make a record.
A record of
He's more concerned about making a record than being released. It's too good.
what, sir? There's nothing else. I'm finding you competent and turn.
No, I know. I object. I want a continuance. I want to have a full-blown competency hearing. I want to subpoena witnesses and all that kind of thing.
Sir, the only thing that happens at a competency hearing is that we would find you incompetent or competent, and they found you competent. So,
Well, I have the right under law to have my own evaluator, because the thing is, there could be
sir, are you saying that you're not competent?
no, I'm not saying that.
Okay, so
But
That's it. That's the whole thing in a nutshell right there. The judge, it's very dry, but she stuck it to him hard right there. Are you saying you're not competent? We had a competency hearing. We got the reports back. They're saying you're competent. You're competent and you're released from jail. I object. You've got to be kidding me.
I still have the right, and I do not have to waive rights.
pursuant to NRS 178.420, I find you competent to proceed with adjudication based on the reports of Drs. Henson and Dr. Dillinger. This will return to District Court Department 12.
And I object.
Sir, were you on electronic monitoring?
I object.
Mr. Blandino, were you on electronic monitoring?
Yes, but I had July.
What level of electronic monitoring?
My house arrest officer said that I should be at lower medium. I served from 7/14 to January 3rd with no incidents or anything. That's almost 6 months with no incidents or anything. And so there's no way, and besides, it puts people at risk with this COVID virus. If he's got to come into the house, got a 94-year-old World War II vet, this is some of the things I need to make a record of.
Mr. O'Brien, do you have any objection to mid?
I'm looking, Your Honor.
Really concerned.
But I have, you know that I want to come to court every single time. There's no way that I am not going to show, and there is no danger to the community issue, so therefore there should be no electronic monitoring whatsoever. Nonetheless, a punitive house arrest, which is what I was on before. I've already been punished, Judge.
Right. I'm going to release Mr. Blandino.
Yeah,
on
right.
mid-level. Yep.
I show house arrest, I don't show what level he was on.
I'm guessing it was high based on the circumstances, but I'm going to release him on mid. I don't anticipate that there'll be a problem.
Can now it's 4 days in the past, 4 to 6 days before I get out on house arrest. Can I be ordered to be released immediately, Judge? I'll report to house arrest.
Return date is May 5th at 8:30 a.m. in Department 12.
Can I be ordered released immediately? By all means necessary. It's going to be 4 or 6 days.
And he gets the hook.
Do we have Jackson?
Do you have Mr. Jackson in there?
Kendall Jackson?
Wow. Oh, that is the best. That was the clip that was sent to me by a viewer. Thank you very much. And then I had to go back. I had done this. It'll all be in my new playlist for Kim Blandino. The last judge said, hey, if you don't get these evaluations, you might end up incarcerated just so we can get the evaluations, which is precisely what happened. Of course, he objected to her. So I got the clip where he's in jail, and I think that's funny. But I wanted an in between. I wanted to see how he got there. So I did a little searching and found that other bit where he gets remanded to jail. I'm guessing that's the remand that put him in jail for this one. But oh wow, this guy is something else. Here at Law Talk, we like to have fun with silly stuff that happens in court, and every once in a while, and completely by accident, I assure you, you might learn something. Thanks for watching.